Okay, still dealing with the Unit 3, dealing with institutions. We're going to look at our federal court systems today. And we're going to begin by looking at the different types of cases there are. But before we even do that, we need to know that Article 3 of the Constitution is going to create the federal court system. It establishes the federal judiciary, but the only court specifically mentioned in the Constitution is the Supreme Court. And so that is the only court that the Constitution created. It gives Congress the power to create all other federal courts. So all of our other federal courts that we'll talk about today are going to be created by statute by Congress. And the judiciary's role is largely to settle disputes. And so that is sort of the role that it will play, sort of as the referee of government. So the different types of cases. There are criminal law cases and there are civil law cases. And so we'll talk about criminal law cases first. These deal with disputes or actions involving criminal penalties. And so the government will be the one that typically charges an individual for violating a statute. So if you commit a crime, whether it be speeding to robbery to murder, you will be brought upon criminal law charges, and the government will be the one to bring these charges against you. And so the different individuals that are involved in the criminal law cases are going to be the plaintiff, and the plaintiff is the individual or organization that brings the complaint to court. And in criminal law cases, the plaintiff will always be the government. And then the defendant will be the one against whom a complaint is brought in a criminal or civil case. And in criminal law cases, the individual or organization that is being essentially tried based upon breaking a law is going to be the defendant. All right. And then you have civil law cases, which deals with disputes among individuals, which deals with the disputes among individuals or between individuals and the government, but they do not involve criminal penalties. And the two most common types of civil law cases are going to be contract cases, where one party violates an agreement, and tort cases, T-O-R-T, tort cases, where one individual charges that he has been injured by another individual's negligence or malfeasance. And so typically those are going to be those medical cases that we hear about. And so let's look at some terminology. As we move through the federal court system, I'll be utilizing some terminology, so it's important for you to know some of these terms. We've just talked about plaintiff and defendant, and so you will hear those again. But then there is a term called precedent, and precedent is defined as prior cases whose principles are used by judges as the basis for their decisions in present cases. So when deciding on a case, the court will apply the statutes, but they will also apply how other courts have already ruled on this particular issue, so that things are going to be much more uniform and uniformly applied throughout the different cases. And so precedent is going to play a huge role in how the federal judiciary will decide on cases. There's a Latin term called stare decisis, and it's a Latin term that translates roughly as let the decision stand. And so in stare decisis, it's the reliance on precedent when an issue has already been brought to a court and a ruling has been issued. And so typically, if an appellate court or the Supreme Court do not want to take up an issue, they'll say this has already been decided, and we are going to just allow stare decisis to stand. And the Supreme Court utilizes this to, quote, promote the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contribute to the actual and perceived integrity of the judicial process. So it's not going to be where different cases involving the same topic are going to be applied differently. It's going to provide integrity and uniformity to all cases that are brought before the federal judiciary. Now, there are state courts. Because of federalism, we have a dual system of courts. Each state is going to have their own set of courts for state laws, And then there's the federal courts that are created to enforce federal laws. And so state courts enforce the laws and statutes of a particular state, and 97% of cases are heard in state courts. And so states have differing types of court systems, but they typically will model a similar structure as the federal level. There will be a trial court, there will be appellate court, there will be a state Supreme Court. And so when you take Texas government, you'll talk about the Texas state court system. Federal courts, again, that's that second level or that second type of court system that plays out in American federalism. So anytime a federal statute, a treaty, or the Constitution is involved, the jurisdiction is going to fall in the federal court. And so that brings us to the term jurisdiction. And jurisdiction is the sphere of the court's power and authority. So if it is in the state of Texas and it's against the law in Texas but not against the law in the federal courts, then the state courts of Texas have the sphere of jurisdiction and the federal courts do not, and vice versa. So it's going to, where jurisdiction occurs is really going to determine where your particular case is going to be tried. And then the writ of habeas corpus. And the writ of habeas corpus is a court order that the individual in custody be brought into court and shown the cause of her detention. So the Constitution specifically says that you, if you are arrested, have the ability to request a hearing in front of a court to determine if the reason you have been arrested is an actual reason and there is cause to restrain you. And this cannot be suspended, although it has been suspended in the 1860s by President Abraham Lincoln during the Civil War. It's not supposed to be suspended, and it's supposed to be one of those rights that the accused enjoy. So let's start looking at the different levels of federal court. And so if we start at the bottom and we work our way to the top, the bottommost level of the federal court system is going to be the federal district court. And as I said, it is the lowest level, and they hear about 300,000 cases per year. There are 94 federal district courts in the United States. Okay? They divide it up geographically, and they are going to be staffed by 678 different district judges. Any federal judge, whether they be on the federal court at the lowest level or they be at the Supreme Court level, are appointed by the president and approved by the Senate. And so these federal court judges and the federal district courts are going to be appointed by the president. And when you are a federal judge appointed to the bench, you serve for life. So you can either resign from office, retire from office, die, and in some smaller cases be impeached, but you essentially hold your position for life. Okay? District judges are assigned to district courts according to the workload. So the busiest districts might have as many as 28 judges, but some of the less busy districts will have fewer. Only one judge is assigned to each case, except where statutes provide for a 3-judge court to deal with a special issue. So typically your case is going to be heard by one judge. Okay? And district courts provide the official record of the case. This is where it's going to be tried. When it goes on to the appellate court in the upper levels, it is not retried. They don't retry it. They don't hear new evidence. They don't interview new witnesses. What they do is they just review what has been done at the district court level. So at the district level, this is where you're going to have your trial. And so the procedure is that they must have a grand jury to hear evidence in order to indict you. If you are indicted, you must have a 12-member trial jury, and you must have a unanimous jury verdict in order to convict. And this is not always the case at the state level, but this, remember, is at the federal level. And so federal district courts have what is known as the original jurisdiction, which means that they have the authority to initially consider a case. And it's going to be here where the decisions are made. Now, if you want to appeal this, then you can go to the next level. So your case has been tried, you have been convicted, but you don't think that it was done properly. you can appeal this to the next level of the federal courts, which is the appellate courts. The appellate courts have what is known as appellate jurisdiction. Okay? They do not have the ability to retry the case. They only have the ability to hear appeals from lower courts. And so what this means is that they do not take new testimony, they do not take new evidence, they simply take the case as it has been tried in the federal district court, and they review it. They review the case, they make sure that proper procedure was followed, they ensure that you got a fair and speedy trial according to all of your rights. Okay, and if you have and everything looks good, they typically will affirm the lower court's decision. They will allow the lower court's decision to stand. Now, if there has been some breach in procedure, your rights have been violated, you haven't been afforded all of your constitutional rights in regards to trials, then what the appellate court does is they kick this back to the federal district court for a retrial. But the appellate court does not retry anything. They simply review what the lower courts have already done. And so they only really review about 20% of lower court cases. And so they're not really going to review much at all. They just review certain things that they feel need to be reviewed, or that make a compelling case regarding if something wasn't followed according to procedure, etc. And in the appellate courts, we have 13 total appellate courts in the United States. We have 11 that divide up the nation geographically. We have one specifically for the District of Columbia, and we have one for patents, trademarks, international trade, and claims against the federal government. Okay? And there are 179 different judges that sit in the appellate courts. Typically, more than one judge will review every appeals case. Normally 3, but sometimes more. So they're going to pay more attention to the appeals cases. They're going to have a panel of 3 judges that will look at the appeals, sometimes more if necessary, and each member of the Supreme Court is assigned to a specific appellate court circuit. Okay, so a specific one of these appellate courts, the Supreme Court justices are assigned to, and they help to sort of oversee this appellate process. So there are some safeguards in place, because typically this is going to be your court of last resort. The Supreme Court takes very few cases, and the Supreme Court is that next level of the federal court system above the appellate courts. So if it doesn't get fixed in, you don't think it gets fixed the way it should at the appellate court system, then you have exhausted all of your options, and the appellate court is typically the court of last resort. Okay, so the appellate court, as I said, is the court of last resort, and that's typically going to be the end of the process for a trial. And so there are those safeguards in place where more than one judge will review your case, and a Supreme Court justice will sort of oversee that as well. And so the next level is the level that we are most familiar with, probably. It is the Supreme Court. And while most of the federal district court, or the federal court, while most of the federal judges and most of the decisions are made in lower courts at the federal level, the Supreme Court is the one that we often see more in the media. But they only deal with a very few amount of cases. They are the highest court in the land. And they are, as I've already said, the only federal court established by the Constitution. Now, the federal court is, the federal Supreme Court is made up of 9 justices. You have 1 Chief Justice who presides over the court's public sessions and conferences. They are the first to speak and to vote, but they still only get 1 vote. They have no higher voting power than the other justices on the Supreme Court. But depending on the Chief Justice in power, they can also be very influential on the court, so they can sort of influence other people to vote in certain ways. And then you have 8 associate justices. Now, the court does not determine the number of justices that are on the Supreme Court. In fact, this has varied throughout history, and there have been 6. We started out with 6 through the early to mid-19th century. Later, 7 was added, and then the final number that we have operated under for a very long time was set in 1869 at 9. But in 1937, President FDR is going to try to create a scheme where he expands the number of associate justice or people on the Supreme Court to 14, because he was in the middle of trying to ensure that the United States worked through the Great Depression. He was instituting all these New Deal policies, and the Supreme Court kept striking them down. They didn't like them. And so because of this, the president, Franklin Roosevelt, he is going to ask Congress to expand the court so that he can appoint more. Because remember, Supreme Court justices are going to be appointed by the President of the United States. And so if he's able to appoint, 5 more justices, then he can get the vote to swing in his direction. Congress says no, we're not going to do that, but the Supreme Court sort of recognizes that this could potentially happen, and so they start to become a little bit more favorable to the New Deal legislation that is passed through under the tutelage of FDR. So we still operate under 9 Supreme Court justices. And as I said, the appointment of justices is by the president, but it must be approved by the Senate. The Senate has the ability to say yes or no to a president's nomination. And even though there are only 9 on the Supreme Court, the president nominates all federal court justices. So all of those at the federal district level, all of those at the federal appellate level are going to be appointed by the president. So he actually appoints way more judges than we sort of probably understand or give him credit for, because we typically only see when a justice on the Supreme Court is appointed. We don't really pay attention to when judges on those lower courts are appointed. And so what I want to do is I want to look at some interesting cases of individuals on the Supreme Court. This Supreme Court nominations have become a very political process. It's not supposed to be, and individuals who are appointed to the bench are not supposed to really have much of a political philosophy when they're deciding cases, but we know that not to be how things play out. Things look much different in theory than they do in practice. And so I want to look at a couple of situations. And the first one I want to look at is Robert Bork. And Robert Bork was an individual who was nominated to the Supreme Court by Ronald Reagan, but he had served in the Justice Department for President Nixon. And he becomes best known as Nixon's henchman in what becomes known as the Saturday Night Massacre. And so one Saturday night in Nixon's administration, Nixon decides that he wants to fire the special counsel that has been investigating Watergate. There has been a special counsel that is investigating the Watergate break-in and all that scandal. And Nixon decides that he wants to fire that individual. And so he orders the Attorney General to fire that individual. And the Attorney General says, "No, not I," and resigns immediately, effective immediately. And so Nixon goes to the second highest member of the Justice Department, the Deputy Attorney General, and orders him to fire the special counsel. And the Deputy Attorney General says, "No, not I," and he resigns effective immediately. And so he goes to the third ranking member in the Justice Department, an individual named Robert Bork, who is the Solicitor General, who is the Solicitor General. We'll talk a little bit more about that individual or that role later, but he asks Robert Bork to fire the special counsel, and Robert Bork does. And so there is going to be some significant outcry regarding this and Robert Bork's role in firing the special counsel. Now, just to sort of help you out here, and like 11 days later, they reappoint a new special counsel and determine that the president doesn't really have the ability to fire the special counsel. But Robert Bork sort of gets this reputation. And so fast forward to Reagan's administration, and he's nominated to the Supreme Court, and there is some significant outcry regarding his nomination to the Supreme Court, not only for his role in the Saturday Night Massacre, but some of his decisions that he has made as a federal court judge previously. And so, by and large, the president will know if his nominee is going to be approved or not. And so typically, if he sees the writing on the wall and sees that the nominee can't be approved, or the Senate won't approve them, he'll either withdraw the nomination or the nominee will withdraw their name. But Robert Bork went to a full Senate vote, and he was defeated on the Senate floor 42-58. And so that's sort of an interesting fact, because you don't really see that happen a whole lot. Because we want to or politicians sort of want to minimize damage and don't want to have egg on their face, essentially. And so Robert Bork was the Supreme Court justice that would never be. The next case is Clarence Thomas, and he is currently serving on the Supreme Court right now, and he was nominated by President George H.W. Bush, the first Bush. And during his nomination and his hearings on Capitol Hill in the Senate, some interest groups did some investigating into his background and found some evidence that suggested some sexual harassment against an individual named Anita Hill. And so there's going to be a very contentious judicial committee hearing where the testimony of Clarence Thomas as well as Anita Hill is going to be heard. Very, very similar to the Brett Kavanaugh debacle that we saw last year, where Christine Ford, Dr. Ford, and Justice Kavanaugh both testified before the committee. And anyway, so Clarence Thomas and Anita Hill will testify before the Judicial Committee. It's very contentious. It gets very ugly. And anyway, eventually Clarence Thomas is going to be voted on by the entire Senate, and he will win nomination by a very slim majority of 52-48. Another case that's fascinating is Merrick Garland, who was nominated to the Supreme Court in 2016. He was nominated by President Obama upon the death of Antonin Scalia, who had been on the Supreme Court prior to his death. And so President Obama nominates Merrick Garland, but it's an election year. And so the Republicans are going to be the ones who are in control of the Senate. And the Republicans refuse to take any action on Garland. And so they have to schedule Judiciary Committee hearings, and he has to be voted out of the Judiciary Committee to the Senate floor, and then the Senate has to have a vote. Well, the Republicans refuse to have a hearing, a Judiciary Committee hearing on Merrick Garland, because it's an election year. And they would prefer to wait till after the election to determine who, would get to name a new nominee to the Supreme Court. And so they really take a gamble, because it could have been Hillary Clinton. But their gamble pays off, because President Trump is going to win the election. And so when Obama leaves office, Merrick Garland's nomination dies. And when Trump takes office, then he is going to nominate an individual named Neil Gorsuch, who will then go on to be confirmed. And then we all have heard about the Brett Kavanaugh debacle of last year. He was nominated by President Trump, accused of sexual misconduct and harassment by some individuals from college, but it became a huge debacle. And so the whole process becomes extremely partisan because the Supreme Court enjoys the power of judicial review. And judicial review is the power to declare actions of the legislature and the executive branch unconstitutional. And they didn't get this power constitutionally through the Constitution. They got it through a case that they passed themselves called Marbury versus Madison in 1803. And so it becomes very political and partisan because of judicial review, but in actuality, the Supreme Court does not really strike down very many acts as unconstitutional. In the past 200 plus years since they have gotten the power of judicial review, they have only struck down 160 acts as unconstitutional. But they have this power, and it's a lot of power, because they are unelected individuals, they serve for life, and they have the ability to influence policy in the United States. So this is the current makeup of the Supreme Court as we see it right now. This is Neil Gorsuch. He was the appointed by President Trump. This is Sonia Sotomayor, who was a justice appointed by President Obama. This is Elena Kagan, appointed by President Obama as well. And this is Brett Kavanaugh, appointed by Donald Trump last year. And then down here you've got Stephen Breyer, who I cannot remember exactly who appointed him. It might have been George H.W. Bush, but I can't remember. Clarence Thomas, who is that individual we talked about a little bit earlier as that one of those sort of fascinating cases, but he's nominated by President George H.W. Bush. Then this is the Chief Justice here in the middle, and his name is John Roberts, and he was appointed by President George W. Bush. And this is Ruth Bader Ginsburg, and she was appointed by Bill Clinton in 1993, and she is a workaholic, very old, has worked through pancreatic cancer, has worked through broken ribs, but she has this huge cult following right now, a very liberal justice that has a huge cult following. And then you have Samuel Alito, who was appointed to the Supreme Court by George W. Bush as well. And so this is sort of the makeup of the court at this point in time. All right, so I'm going to break this lecture up into two parts again, like I did the other elections. And when we come back, we're going to talk about the process of the Supreme Court, how they go about accepting cases and working through those cases. And then we'll talk about judicial philosophy and a little bit of trivia. So I'll see you then.